Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Diane O'Connell shares general terms and conditions that might be in the wrong place. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen, here with my friend Diane O'Connell. Diane, how are you today?
I'm doing great, Mike. Thanks for having me.
We got a weird one. Yeah, we're excited because we got a weird one. We just had like a whole back and forth, like, what the heck is this? Which is always a great way to start a conversation about contracts. I'm going to share this document with the folks at home. This thing is called General Terms and Conditions Relating to Aurora Innovation Services. It says by and between Aurora and the customer, capital C. Diane, what is this document? When are we going to see this kind of thing?
This is a puzzle because it's called the terms and conditions. It refers to a master service agreement, but it's got terms and conditions of a master service agreement, and it doesn't really make sense the way it's structured. So as we tear it down, we're going to try to figure out what their goal was and how they could have done it better.
Boy, that's a really good pivot because starting with the goals, there you go. Okay, so we're going to intuit a little bit, but we're going to take this document on its face here for a second and assume that they mean to do what they're doing, and then we'll step back and ask questions about, if you mean to do something else, how would you change the way that they did this? So if I'm understanding correctly, Aurora Innovation AB, which is not the same as Aurora Innovation in the United States, is healthcare technology service of some kind. They're protecting data. They're creating a patient platform, patient portal for medical services to communicate with patients. Cool. So let's take that on its face. So that means that they're A, in Europe, presumably mostly, that's where they're based out of, and B, they're dealing with a lot of patient data, and we've had conversations about how wacky that little world is. So let's jump down to 7.1 and 7.3, 7.4. So this section is called Use Rights and Intellectual Property Rights. So presumably, Aurora, we don't have the Master Services Agreement, which it keeps referencing, but Aurora is going to do, because of the work that they do, they're going to do some kind of technology services related to healthcare. They're going to build some kind of patient communication platform. In that, they are making some stuff, some technology. Here's what they say in terms of usage right. During the term set out in the MSA, Aurora hereby grants to the customer a non-exclusive, non-sublicensable, and non-transferable right to use the services in accordance with the terms and conditions of these general terms and for the purposes herein. So if I'm understanding that correctly, they're making some stuff, and they're saying, hey, you company, you get to use this stuff as long as we're friends. Am I reading that right?
I think you're reading that right. That's right on. I mean, the one thing I would say is missing in here is, given the fact that it's a company based in the EU, it does not offer a worldwide license, is missing out of it. So if you're going from country to country with different copyright and intellectual property laws, and we all know that U.S. has an issue with China taking intellectual property. You'd have to actually register this in every single country, and they haven't issued a license for people to use it in different countries. So I'd say just right off the bat, 7.1's got that gap in it.
Got it. So as a general purpose, this isn't work for hire or something where everything Aurora makes is, belongs to company Bob, whatever. Right. This is all part of the agreement. You're hiring us to do this. Cool. So, let's go down to 7.3 because this digs a little deeper into it. Any intellectual property rights vested in, e.g. without limitation, any software, drawings, technical solutions, documentations, materials resulting from any development of the services shall be owned by and the sole property of Aurora. During the term of the agreement, the customer is granted a non-exclusive, non-sublicensable, and non-transferable right to use the result of such development. So again, it's saying we're going to make something for you. It sounds like, and tell me if I'm intuiting this correctly, they're making something new, perhaps. They're saying, we have this general framework for patient portals, but Hospital Bob, we're going to go make a new one for you, and it's cool. You get to pay us for it, but you don't get it. Is that what 7.3 is saying? How would you deal with that kind of, we have some stuff, but we're going to adapt that stuff to you, but it doesn't mean it's your stuff? What are you seeing in there?
Yeah, I mean, it is saying that, but it's also... it's drafted a little bit broad, because what it's not saying, and what nowhere in the agreement is saying, is that who's creating it, who's developing it. It's not saying any intellectual property rights vested in any software, drawings, technical solutions, documentation, materials resulting from any development of the services by Aurora. It's saying anything that was developed resulting from any development of the services. Now, a lot of companies, they'll have their own IT guys that will develop certain things on their platform to make it compatible with, say, the Aurora systems. Because of the way this is drafted, the broadness of it, that intellectual property technically would belong to Aurora because it was part of the services. So this section is not really clear on, well, it is clear in a way in that Aurora thinks that anything that's developed in connection with them working with a customer, they should own. But that's not necessarily the case. And if I was the customer on the other side, I would absolutely push back on this clause, because some of the stuff is going to be proprietary to the customer. Some of it's going to be developed by the customer. So what happens with that intellectual property?
All right. As we mentioned initially, Aurora's in the healthcare field, right?
Yeah.
So as we know, we've had episodes previously about how to deal with healthcare data. I'm remembering the one that we had with Arohi Kashyap, where she went through like crazy details what you have to do with healthcare data. 7.4 tips the hat to healthcare data and waves at it as it passes by. It says the customer is responsible for any data, patient data, or other patient-related information. It generally is just shifting the responsibility. They're a platform. There's whatever the equivalent of platform liability restriction is in Europe around this kind of thing. I don't know if they could do that. What are you seeing in 7.4 in terms of patient data being brought up in this gig?
7.4 is it really is a standard term that's put into a lot of software agreements or development agreements where technology companies go in with this product or service that they have that gets installed onto the customer's servers. And then the customer, they work together to integrate it and customize it so it works, and then you put the data in. And so it really is kind of a collaborative type of service that they're offering. But when you're dealing with patient data, you can't absolve yourself of the responsibility. So for instance, if there's a breach in Aurora systems and somebody is able to hack it and put it on the dark web, then they can't push that responsibility onto the customer because it was actually on Aurora's servers. So it's where the data is located, if you want to say that, because it's not really located anywhere. But if it's transferring through Aurora systems, then technically Aurora has possession of it and they're responsible for it. Now, a lot of these companies argue that we're not storing any data, so all the data responsibility is on the customer, but that's not really the case, because when you're dealing with the internet, it's really, what part of the system is transferring the data at the time that it was breached. And so I think 7.4 should be without a doubt, there should be more specificity in there about what Aurora is doing and why they don't think they're responsible, or how they would be responsible in certain circumstances based on where the data is at any given time.
Yeah, as not Aurora's lawyer, I would encourage you to go back and watch the episode with Arohi Kashyap talking about the business associate agreement, because I'm pretty sure you want that longer. And actually, this touches on something we're going to get to later, is maybe it lives in some other document that we don't know about, in which case, why are you talking about it here? But 7.6. Let's go down to 7.6. Aurora agrees to indemnify the customer against... Okay, so Aurora is indemnifying the customer in their own document against third-party claim that the customer's use of the services or parts thereof infringes such third party's intellectual property rights. So Aurora's taking responsibility for we're making the stuff. If we stole, it's our bad.
Right.
Obviously, they limit it a bit. What are you seeing in 7.6?
I mean, this is a typical clause that they're going to agree to indemnify for any third-party infringements. I think where I got more of the indemnification only provided the... So where I saw that a little bit of sketchiness in here is the second half of it, where it says, moreover, the indemnification obligation under this section 6 shall only apply provided that the customer immediately notifies Aurora in writing about the claims brought against the customer. Now, what's your definition of immediate? My definition of immediate living in New York City is much different than somebody's definition of immediate in Conrad, Vermont, or Augusta, Maine. Like, my idea of immediate was like 5 seconds ago. Whereas, if you're in a rural town, immediate might be like in a day or two. So that itself is ambiguous.
I lived in Italy for a little while, and I think I could say with some confidence, there are European enclaves where time is not real, okay? It's a social construct. They're not paying attention to it.
Yeah. And like in the Caribbean, there's the term island time for a reason. So, what is immediate? I'm normally, when I would negotiate this, I would say, promptly or as soon as is practicable or, something like that. I mean, you have to have a little bit of leeway than the immediate. Like, do you open up the mail and go, oh my God, we have to, contact Aurora immediately?
Yeah.
So, and the other part of it too is that it allows Aurora the sole control of the defense and solely to decide on all related settlement negotiations. Now, I would never agree to this if I was negotiating it from the customer side. And the reason being is that there is certain things like the customer knows their business better. The customer has a reputation to uphold. So let's just say, for instance, it's Empire Blue Cross Blue Shield. They have a reputation. So for Aurora to take control of the defense does not take into consideration Empire's positioning in its marketplace. And so usually I would try to negotiate this so that it said, Aurora doesn't take sole control, but Aurora and customer collectively will defend the claim and cooperate with each other in that, because they both have different interests. And let's face it, if Aurora breached third-party intellectual property rights, the customer, how good is the relationship going to be now that they've breached the contract? Are you going to trust Aurora to actually defend your reputation on that? So there's that. And then the third part of it says acts in accordance with Aurora's, which this part doesn't make any sense. So on one end, Aurora wants to have the sole control of the defense and solely decide on all related settlement negotiations, but they also want the customer to act in accordance with Aurora's instructions and at customer's own expense cooperate and assist with Aurora. Why is the customer going to do it at their own expense? And what are they cooperating with if Aurora's taken over the entire defense anyway? So all of this is a little bit like nice try, but if there's a third-party intellectual property claim and it's likely that it's Aurora's issue, they really should be a little bit kinder and cooperative with their client or customer, as they're named here, so that the customer actually may continue to use them after the fact. The way this is written, I would never use them again.
Speaking of nice try, let's jump down to the warranty and limited liability. This is under 11. Okay, so 11.1. The customer acknowledges that the services are standard services and are delivered as is and except as explicitly provided, blah, blah, blah. I'm assuming standard services means something to someone. It is not capitalized, but I assume it means non-superhero services. What is this disclaimer of warranty doing? What is standard services as is? What are these words doing in here?
Standard services, I have no idea what those are. They're not defined in here, and maybe they apparently aren't defined anywhere because they're not capitalized. But so I don't know what standard services are, but I'm going to make an assumption, which I know what, when you assume what you make yourself, but let's just go with it for now, is that if they're standard services, to me, making an assumption that would mean that they're going to provide, I'm going to use a 1980s or 90s term, like, here's a floppy disk, stick it in the machine, you got the software, that's it. We're not customizing it for you or anything else, which is a little bit in conflict with what it says earlier in the agreement. So if they're standard services and they're like, why couldn't the company just buy it on the internet and download the software from their website like everybody else does? Why are we entering into this agreement? And if you're going to enter into an agreement, especially when you're dealing with the exchange of healthcare data between providers and patients, you can't say it's as is. You can't say there's no warranties. What? You're going to give me a piece of garbage that has malware in it or some kind of bug. I'm going to install it on my systems. It's going to transfer all of that information to North Korea so that they have all the information of Empire Blue Cross Blue Shield patients, or so trying to say that this is as is a little, which is something a lot of software companies are doing now, but it is really, it sticks in my craw, I would say.
Yeah. Because you can't do that. I'm going to come back to your floppy disk reference. So for the kids, if you guys want to pause this and go figure out what the heck a floppy disk is, we'll give you time. In the meantime, we're going to jump down.
Because that's the only thing I had nearby.
We're going to look down at 11.4 real quick, the limit of liability. It says Aurora's aggregate liability under the agreement shall per calendar year be limited to the amount equivalent to 12 months of service fees. This is pretty common language. What are you seeing in that limit of liability there?
One thing is it says it's going to be equivalent to the amount, to an amount equivalent to 12-month service fees. Now, service fees paid, service fees due, service fees owed.
And this is a general terms, by the way. So service fees, like we don't even have any idea what those service fees are at this point.
Right. And maybe that's part of it, is that it's called general terms and they're drafted so generally that we don't really understand how to operate under the contract.
Okay, so before we jump to that, but general principle, how do you feel about 12 months? Like I see this a lot. I'm going to limit the liability to 12 months. Just in principle, what do you think about that?
I think it's a nice way to try to limit your liability. If you bounce back up to 11.3, though, it gets into the fact that Aurora is not liable to the customer for any third party in any matter for any indirect damages of any kind, lost profits, lost sales, lost revenue, lost use, regardless of action. Now, so what they're doing is they're limiting their liability to only direct out-of-pocket costs. They're limiting it to 12 months fees. Now, if there's a data breach under HIPAA or European healthcare rules, data privacy rules, those can cost millions of dollars. Like one small piece of software can cost the company like 8-digit, 9-digit millions of dollars. So to try to limit your liability to just 12 months of the service fees in this kind of a context, it's a little bit of a tough nut to swallow. Also, in addition, if I'm going to combine the 11.3 with this, if you exclude indirect damages, lost profits, lost sales, lost revenue, again, most of these data breaches involve the companies then sending an email out to everybody saying, okay, you have a year's worth of experience security protection. And, it really costs an awful lot of money, and those are indirect damages. Those are indirect costs. Now, you can argue they're direct costs, but then again, you have to redefine a little bit more clearly what direct costs are. Is it the cost of fixing the software? Is it the cost of defending the HIPAA claims that are being brought against you? Resolving the data breach? Like, what are direct costs? So, And what about your shares then? If your shares go down, are those indirect, lost profits? It's a bit mushy in this area. I mean, in some cases, these terms work because it's a quick, simple, I don't know, like if Calendly had a desktop software and they put it in, then it would be like, okay, fine. You can limit it to this. But in these cases where you're starting to deal with tricky information, that can be very costly. I think these are,
you talk about that Calendly download. Again, for those of you who don't know what a floppy disk is, go find the save icon on any app that you're on. That's what it is. They used to store things. And time was you would buy software and somebody would give you software and then you'd have software. And that was it. There was a day it was delivered. You'd have it. I'm looking at this document, which again is called General Terms. It makes a reference to a master service agreement. And it seems to, I mean, this whole industry is kind of playing both sides. Is this more like a delivered product? Is this more like a long-term, it's called software as a service for a reason. Is it this long? And there's this kind of confusing kind of overlap of these two worlds. I'm looking at this document. I see a lot of language that's basically like, you bought our floppy disk, bro, you get what you get. And we're going to limit the cost to the thing that you bought of the thing. And then I see attached an SLA, and it's referring to an MSA that screams to me, this is an ongoing relationship. This is more like, you know, you have a lease or something. Like the relationship's different. What are you saying? Why is there a general terms and conditions? Why is this stuff not in an MSA? When would you even use a general terms and conditions? Is it better for the floppy disk situation? Why is this not translating to me? Fix me, Diane, fix it.
If I could fix this, I could save the world.
Yeah.
Here's my thoughts on it. I think number one, because this company is based out of Sweden, perhaps maybe they had a different approach, and maybe what they did was wrote it in Swedish, and then when it was translated, it got the way it's structured changed. When I see things like general terms and conditions, usually it's because there's a master service agreement that's very slight that says, here's, you know, we enter into an agreement between Diane and Mike, you know, and we're going to do business together. See the general terms and conditions, see the SLAs, see the country appendixes. So the general terms and conditions, in my experience, are best used when you have that kind of multinational MSA, where you have like the little brief MSA that says, hi, Mike and I are friends now, we're going to do business together. And then here's the general terms and conditions for everybody in the world that we do, you know, that Mike wants to share it with, like in his company. And then we're going to attach some country schedules to it that override the general terms and conditions to make sure that if there's changes in certain laws or differences or conflicts in law, that they're addressed country by country. And that's usually where you see something like the general terms and conditions would be attached to the MSA, and then backing it up would be these country schedules for multinational contracts.
Gotcha. So
what would be the point of having a general terms and conditions if you had nothing but the general terms and conditions? Then they're just terms and conditions.
Yeah. So you're just not going to fix this for me? You're just not going to make me feel better about this. That's what I'm hearing.
Well, I'll tell you what. I can make you feel better. What we can do is we can smack on a little MSA in the beginning. We can put a United States country schedule at the end. And then we have a good agreement.
Yeah. Yeah, all referencing back to each other in some vague way. Well, I appreciate you bringing this to me. Maybe the lesson here is that no document lives on its own, buddy, especially if you're going to have a long-term relationship. So make sure you've got the web figured out. Diane, thank you for bringing this. For people who want to learn more about you, maybe connect with you online, what's the best way to do that?
I would say LinkedIn.
Okay, cool.
Absolutely.
Well, I'll make sure to have a link to your profile over at the show notes at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We would love to have you. Diane, thank you, and we'll see you all next time.
Thank you, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.